Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will be discussing about capital punishment in India. First of all, let us understand what is the current affair that is related to capital punishment in India. We will see that there are increasing views on the abolition of capital punishment in India. And considering all these views, in order to abolish capital punishment in India, it requires a serious consideration. So, in this lecture, we will analyze whether capital punishment is required in India or not, whether there is a need to abolish capital punishment from India. Before going to the analysis of whether we need capital punishment or not, let us first understand what is the evolution of capital punishment in India. Now, first of all, if we consider the first 5 years after the constitution was made, we will see that death penalty was a normal punishment for murder. If a person commits a murder, the person will be awarded with a death sentence or death penalty. And this was very normal, and this was during the first 5 years after the constitution was made. And this practice changed in 1955. So till 1955, if a person commits murder, the person will be awarded a death penalty. Now again in 1955, this was changed, and what happened? The sessions judge was given a discretionary power. So the sessions judge was given a discretionary power to award either two sentences. So he was given a choice. So what was the choice? Either capital punishment or life imprisonment. So if a person commits a murder, the sessions judge has the discretion to award him either capital punishment or life imprisonment. Before that, it was normal to award a capital punishment for committing murder. Now again, we will see that in the year 1973, CRPC was amended. CRPC is the Criminal Procedure Code. So CRPC was amended in the year 1973, and by amending the CRPC, Parliament made it mandatory that the sessions judge, if the judge is awarding a capital punishment to a person who has committed murder, he has to show the reasons. That means a sessions judge, while awarding the sentence, whether it is a life imprisonment or a capital punishment, he or she, the judge, has to show the special reasons why life imprisonment is awarded or why capital punishment is awarded. Now later on we will see in the famous Bachchan Singh case, the Supreme Court ruled that death penalty could be imposed only in the rarest of the rare cases. So this phrase might have been heard by many of you. The Supreme Court ruled in Bachchan Singh case, this is very important. Supreme Court said that only in the rarest of the rare cases that a judge or a court can rule for a capital punishment. And this rarest of the rare cases means that alternative sentence of life is unquestionably foreclosed. Again, coming to Machi Singh versus State of Punjab case. This case provided some exemptions to the earlier judgment of the Supreme Court, that earlier in Bachchan Singh case, the Supreme Court has ruled that only in the rarest of the rare cases, a person can be awarded death penalty. But in Machi Singh versus State of Punjab case, this clause, that is rarest of the rare cases, was given certain exceptions. So what are they? First exception was that if murder is committed in extremely brutal manner, the first exception is if the murder is committed in extremely brutal manner so as to arouse extreme indignation of the community. The second exception was that if the murder is committed by a motive which evinces total depravity and meanness. And thirdly, if the crime is enormous in proportion. So these three exceptions were given in the Machi Singh versus State of Punjab case. So this is the evolution of capital punishment in India and how it has taken its present form. Now let us understand what are the protections guaranteed under the Constitution. The first one is Article 21. So the Menaka Gandhi case held that Article 21 affords protection not only against executive actions but also against legislations. So what does it mean? It means that a person can be deprived of his life even under capital punishment only if there is a law which is just, fair and also reasonable. So what does Article 21 of Indian Constitution say? It states that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. Now the second protection is provided under Article 72. Article 72 of the Indian Constitution says that the President can pardon even death sentence, while the governor in a state cannot pardon death sentence. Now, Article 72 of the Indian Constitution empowers the President with the power of pardoning. It is also called the pardoning power of the President. Now, again, even when the pardon is denied by the President, there is a scope for judicial review. And judicial review can be conducted if the presidential decision not to pardon the death sentence is arbitrary, irrational and discriminatory. Now again, Article 134 provides that there is a right of appeal from the High Court verdict to the Supreme Court, and this is applicable in any case where capital punishment was imposed on an accused in reversal of an acquittal order. So from all these constitutional provisions, Article 21, Article 72 which provides for the pardoning power of the President, scope for judicial review, and also Article 134 which provides for right of appeal, all these constitutional provisions points out to the fact that death row prisoners has been humanized under the Constitution itself. Now let us understand what is the way ahead or what has to be done. First of all, let us understand what are the objectives of punishment in Indian judiciary. So there are mainly three objectives for punishment under Indian judiciary. One is retribution, second one is reformation, and the third one is deterrence. So what are they? First one, retribution. So what is meant by retribution? It means that a person has done some offense, and for that offense we are giving him some punishment. So if a person commits a crime or an offense, what has to be done? The person will have to be given some punishment. So retribution means a punishment given for the action or for the offense committed by a person. Now second objective is reformation. Reformation means through the punishment process, the judiciary is trying to reform that person. It means to change the criminal character of that person so that in the future the person does not commit any crime or any offense. Now what is the third objective? It is deterrence. So what is deterrence? Deterrence means the action of discouraging an action or an event. That means by providing punishment, a person is discouraged to do something. It can be an offense or a crime, and this is done by creating a fear of the consequences. So when you know that if you commit a particular crime or a offense, you will be punished. So what will you do? You will not do that. So that is the objective of deterrence. So these are the three main objectives of providing punishments to a person who has been involved in an offense. Now let us consider the second objective, that is reformation. So the theory of reformation is based on the obligation of a society to reform a convicted person. Suppose if a person is convicted for a particular crime, so the society has a duty or an obligation to reform that person in order to provide that person another opportunity of living or a better opportunity of living. So through punishment, the person is supposed to be reformed. He is a new individual now. He is a changed individual. So what happens? The society has the responsibility to accept that changed individual or reformed person, and it is the obligation of the society to reform a convicted person. Now what is the question here? Under capital punishment, this objective of reformation is completely defeated. What is the reason? Under the theory of reformation, what is stated? Society has the obligation to reform a person and to provide a better opportunity of living. But under capital punishment, he is denied his right to life. The offender does not continue to live. So how will he get an opportunity for a better living or another opportunity to live his life? Now the theory of reformation is defeated. Now secondly, if we consider the third objective, that is deterrence. We have learned what is deterrence. Deterrence means discouraging someone to do something by creating a fear. That means if a person know that he will be punished or she will be punished for a particular offense or a crime, he will be discouraged or she will be discouraged to involve in such an offense or a crime. So under the theory of deterrence, a person is demotivated or discouraged to do a particular thing that can be an offense or a crime by inducing fear that he will be punished or she will be punished. So what is the question here? there is no sufficient proof to show that death penalty operates as a greater deterrent than the life imprisonment. That means it is not possible to prove that death penalty can be a greater deterrent than life imprisonment, or death penalty can discourage more than what life imprisonment can do. Now the third question is with regard to a mistaken conclusion by the judiciary. If suppose in a subsequent occasion it is discovered that the judgment which was passed was a mistaken conclusion, in that case death penalty is unrectifiable. The person is no more, so judiciary cannot rectify its mistake. Suppose when the judiciary ruled out for a death sentence and in later circumstances judiciary feels that the evidences which were against the offender was not true, and later stage what can the judiciary do? Nothing can be done because death penalty is unrectifiable. The person is no more. Now the fourth fact is the arbitrary nature of the death sentence. What is meant by arbitrary nature? It means that without any reason or any evidences, it is based on personal choice. In the year 2015, the Law Commission said that the constitutional regulation of the capital punishment has failed to prevent death sentences from being arbitrarily imposed. It means that we have seen there are certain constitutional provisions that safeguard death sentences, like the Article 21 or the pardoning power of the President or the judicial review, etc. So there are constitutional remedies or safeguards, but these safeguards were not able to protect the offenders from imposition of capital punishment which are of arbitrary nature. It means that in most of the times death sentences are awarded not on the basis of the evidences or the facts that exist, but it is based on the conclusion of the judiciary. And the Law Commission in 2015 also observed that there is no proper mechanism in order to check the arbitrary nature of imposing death sentences. So the Law Commission as a conclusion suggests that in such circumstances existing, that is death sentences being imposed based on arbitrary nature, it is good that the death sentences are abolished. Now as a conclusion, if we consider the second and the third objectives of the punishment in the Indian judiciary, that is reformation and deterrence, death sentence does not provide a solution to both of these objectives or theories. And also considering the recommendations of the Law Commission and also the irreversible character of the death sentences, it is good that death sentences are abolished in India. You can find the PDF of this lecture on my Facebook page, and for any queries related to your UPSC preparations, you can get in touch with me on my Facebook page, or you can email me at joyce.studyiq@gmail.com. Thank you.